Cespedes? Here. Commissioner Patman? Commissioner Singh? Yes. Chairman Hubert?
Here. Thank you very much, Ms. Ackman. I just want to, before we get started this morning, we do have a quorum of the commission. We do anticipate Commissioner Patman very shortly. For those of you who are carrying cell phone devices, we would ask that you turn those off or put them in a vibrate mode during our proceedings today. And also because these proceedings are being recorded, and so they're very sensitive and they pick up everything. And so we'd encourage you also to keep your conversations to a minimum because that will interfere with the recording proceedings as well. At this time, it is always great to be back at Wright State University. Wright State has been an integral part of the commission and its work. They are one of the founders of our Civil Rights Hall of Fame event that we hold every year, and it's always great to be back at Wright State. We do this on an annual basis. And having said that, we're going to ask, I'm going to ask Dr. Bernstein, we refer to him as Dr. B. He is if there was an ex-official member of the commission, it would be Dr. Bernstein because he has been such of support of the commission and its work, and more specifically the Hall of Fame, and so it's always good to see him as well. Dr. B?
Thank you. I would especially like to express our gratitude to Wright State, the commission and the commissioners under their outstanding leadership of Commissioner Hubert and Dr. Michael Peak over here, the executive director, for being here, for returning every year, and an opportunity to go and act. I also just want to make one other comment that a couple years ago I lost a ton of my health before I needed. I was very fortunate in the fact that Lena reached out. Dr. Ryan, the new director, 100% behind this project. We're really glad to have been working with us. Never had been standing over there. Every good organization has somebody who does all the work. Thank you all for being here. We welcome you. If you need anything, please let us know. We'll talk to you later.
Thank you very much, Dr. Bernstein. Commissioners, the minutes from the March 17th, 2016 commission meeting was previously provided to you. Hopefully at this time you've had an opportunity to peruse those minutes and review them. If there are any corrections to those minutes, if there's no corrections to those minutes, a motion would be in order for acceptance and adoption and approval of those minutes.
So moved. Second.
Okay, Commissioners, I'm going to ask you to speak right into your mics. You might have to pull them up a little bit because of the recordings as well as being able to pick up the audio. We have a motion by Commissioner Barrage, seconded by Commissioner Singh, to approve the March 17th, 2016 commission minutes. Are there any questions or discussions on the motion? No questions or discussions on the motion. Ms. Ackman, will you call the roll, please?
Yes. Commissioner Barreras?
Yes.
Commissioner Singh?
Yes.
Commissioner Cespedes?
Yes.
Chairman Hubert?
Yes. Thank you very much. Commissioner, the confirmation agenda is before you. At this time, a motion will be in order for approval of today's confirmation agenda.
So moved.
Second.
There's a motion by Commissioner Cespedes and second by Commissioner Barrage to approve today's confirmation agenda. Any questions, discussions on the motion? No questions, discussions on the motion. Ms. Ackman, will you call the roll, please?
Yes. Commissioner Barreras?
Yes.
Commissioner Singh?
Yes.
Commissioner Cespedes?
Yes.
Chairman Hubert?
Yes. And I know we have a number of students, and we typically do this at when we take these proceedings in our educational session. At the end of the meeting, hopefully we will might have an opportunity. If you have a couple of questions, we'll be more than happy to answer, because so often when we're going through these proceedings, it might sound French, something strange to what we're doing, and so we fully want you to get a grasp of understanding of what it is that we're doing. Typically what happens in the confirmation process is, when you come to these public hearings, and for today, for an example, we have 3 appearances, cases before the commission. Every commission, every filing, every case that is filed with the commission, both parties have the opportunity to request an appearance if they choose to do so. And so often when folks come to commission meeting, and as my kids have told me before, they says, well, you only had 3 appearances today. You guys really didn't do too much work. And someone would think that, but what people don't fully understand is all of the cases that appears on the confirmation agenda today, that requires that the commission rule and act on each of those individual cases. And so that still requires, although no party asks for an appearance, it also requires that all commissioners have to do their midnight reading and prepare for those cases as well. And so often, and sometime, actually, you will see a commissioner bring a case that appears on the confirmation or weekly agendas up for discussion. And sometimes we even reverse the decisions that have been recommended from the staff. So anyway, we will try to use this a little bit of an education process as well as we go through the process today. Commissioners, we're now ready to hear from our staff briefings. Mr. Martin, our compliance director.
Yes, Chairman and Commissioners, the Ohio Civil Rights Commission has complied with all notification requirements under Commission Rule 4112-1-04, and there are no changes to today's agenda.
Thank you very much, Mr. Martin. And Mr. Martin, as we indicated earlier, we do have 3 appearance cases before the commission today. Mr. Martin, the 3rd and final appearance before the commission today, please.
Yes, Chairman and Commissioners, the 3rd and final case to appear before you appears on your Week 3, page 2, item 1A. The case is Stephen Wright versus Kelchner, Inc. Will the parties for this case please come forward? This case comes before you on reconsideration of a prior finding of no probable cause issued on March 17, 2016. The charging party requested reconsideration of this finding and wishes to contest the finding before the commissioners today. Here to present his case is the charging party, Mr. Stephen Wright, accompanied by the NAACP President, Derek Forward, and representing the respondent, Kelchner, Inc., is attorney Ian Mitchell and Karen Van Zandt.
Okay. Thank you very much, Mr. Martin. Thank you, parties. The chair recognizes Commissioner Patman.
Yes, I move that we have a 5-minute recess.
Okay. There's second?
Second.
There's a motion by Mr. Patman, second by Ms. Ross, that the commission would take a 5-minute recess. Any questions, discussions on the motion? Hearing none. Ms. Auckland, will you call the roll?
Yes, Commissioner Patton?
Yes.
Commissioner Barreras?
Yes.
Commissioner Singh? Commissioner Cespedes?
Yes.
Chairman Huber?
Yes, I have 11:57. Let's be 11:58 now. Let's be back at 12:05. Mr. Patman, second by Ms. Ross, for the commission to move from recess to public session. Any questions, discussions on the motion? Hearing none, Samba to give us a briefing on this case, please.
Good afternoon, Mr. Chairman, Commissioners. May it please the Commission, I will present the case of Stephen Wright versus Kelchner Incorporated. This case comes before the Commission on charging parties' request for reconsideration based on the decision of the Commission on March 17th, which found no probable cause of discrimination. Charging party filed a charge of discrimination and also for contacting NAACP during, according to him, his last suspension. The regional office found that the prior determination was that charging party was not promoted because he was not qualified for the position. And regarding his allegation of harassment, the regional office found that there was no evidence to show allegation of harassment. And again, regarding termination, the regional office found that he was terminated due to job performance problems. The record of this case indicates that charging party was hired on August 4th, 2014 as a laborer, and he was discharged in June 2015. Regarding the issue of harassment, it is true that charging party complained internally saying that he overheard a Caucasian white coworker using the N-word. That was the issue of harassment he complained about. And the investigation also indicates that respondent promptly investigated his allegation, his complaint of harassment at workplace. And subsequent to its internal investigation, it was substantiated that charging party's co-worker, Caucasian, admitted saying using the N-word. Respondent promptly discharged that person for using the N-word and for conduct and violation of its policy. So the issue of harassment was handled. Respondent addressed it, took a swift action against the perpetrator of the harassment. Regarding the layoff issue, charging party is alleging that he was laid off because he complained. And he's saying that that was in retaliation. But the layoff, contrary to the allegations, the layoff was not motivated by retaliation. This is a construction industry. During the winter time, it lays off employees. And not only the charging party, other similarly situated, several employees were laid off for the season. It was seasonal layoff, and when spring came, spring 2015, charging party was rehired. As such, the layoff was not motivated in retaliation. There is no nexus between this decision of seasonal layoff and charging party's prior complaint of harassment, which was appropriately addressed. And the other issue raised was that he was denied promotion because of race and in retaliation. Charging party, yes, asked that he be promoted to assistant project manager position. Respondent readily accepted his request and assigned him to shadow another senior, seasoned and experienced assistant manager who was also a black person. And during shadowing to become an assistant manager, the investigation indicates that charging party did not follow the instruction of his supervisor, and he lacked necessary skills for the position. So the promotion was denied due to his lack of qualifications the position required. Another factor regarding the promotion allegation that very much strongly undermines allegation of discrimination because of race is that respondent selected another African-American employee to be trained and finally hired as an assistant project manager. That name is Tamar Peterson, was hired into this APM position. Finally, the investigation indicates that charging party was not discharged because of his race or retaliation. The investigation indicates that he was discharged for job performance problem. It was documented that he was not following directions, and he failed to work to do work required as a laborer, and also he failed to follow general safety rules. It should be noted that in his request for reconsideration, charging party just reiterated his initial complaint. He did not challenge the findings of the regional office, that he was not promoted due to lack of qualification, and his internal complaints were addressed, and he was not promoted due to lack of qualification and discharged because of performance problem. Last but not least, evidence also indicates that prior to charging party's termination, respondent has discharged similarly situated Caucasian employees who were not known to have engaged in any protected activity for same or similar reasons for performance issues. Based on the above, I recommend that the Commission deny charging party's request for reconsideration and uphold the initial finding of no probable cause. Thank you.
Thank you, Mr. Soba. This time we'll move to the charging party since it's their request for reconsideration. Mr. Farmer, you can state your name for the record. You may introduce your parties and you may proceed with your 5 minutes opening, please.
Thank you, Mr. Chairman. Thank you, commissioners, for even electing to open a hearing up for this particular case. And for the record, I typically don't get involved in individual casework. But this particular case, once my chairman of our Labor and Industry Committee contacted me and our paralegal contacted me, and I had an opportunity to review the case and listen at our complainant, it rose to the level of, I thought it was an opportunity to really fight for this young man and in what he believed in. So I just want to state for the record that I typically don't get involved in individual casework. I more or less focus on community issues. But let's just go back to the facts. He was hired on August the 1st. So with me I have Chris Kortner, who is our Labor and Industry Chair. That's the individual who actually fielded the complaint, Mr. Chris Kortner. And then our paralegal is Kathy Parsons. So they work together on individual casework every day at our office. So Mr. Wright was hired on August the 1st, as already stated, August the 4th, 2014, and was terminated on June the 1st, 2015. So he had a 10-month tenure with the Kelchner Construction Company. So I just want to go over a list of questions with our complainant, and I just want to see how he responds so that you can see how he responds to these particular questions. Have you ever been disciplined during your 10-month tenure on the job?
No, sir. No, sir.
Have you ever received a review during your 10-month tenure on the job?
No, sir.
When you were terminated on June the 1st, I know you sent a letter to the company also requesting a grievance. But due to their policies, they don't give a grievance once you've been terminated. But did they give you a copy of your termination form?
No, sir.
Did you request a copy of your termination form?
Yes, sir.
So now let's go over some of the issues related to this particular case. What was the first racial incident that you faced on the job?
In West Virginia.
And kind of talk to us about that particular case.
Me and a Caucasian man, we were working, and through the whole process, we were working, and later on that night, I asked him, "Hey, man, what can we do around here in West Virginia? I'm out of town," and I asked him, "What can we do around here?" He told me that they don't allow niggers to go around in places in West Virginia, with Caucasian people.
Okay. And then, so what was the final outcome? So what did you do next? Did you report that?
Yes, sir. I reported it to Luther Hall, which was our safety manager.
Okay, so you reported it, and then what was the final outcome and disposition of that particular employee who made that statement?
He was terminated.
Okay. What was the second racial incident that you faced while working at Kelchner?
I was in my room with my roommate, also a Caucasian man. His name is John Hightower, and we were talking, and he told me that when, I'm sorry, I'm a little nervous, so I apologize, but I wrote them all down. He told me when I was talking with him that when there's no black people around, every Caucasian man that's on that site, they have a field day with the nigger word. And I lost my breath. I was lost for words.
And what city and state did that happen in?
Cadiz, Ohio.
Okay, so now that's the second incident. Did you report that?
No, sir.
And why didn't you report that particular incident?
It was like he was my roommate. It wasn't like he was the enemy, you know. It was more or less, you know, in confidence. You know, he told me that this is the way things go when you're not around.
Okay, so what was your third racial incident while working at Kelchner Construction Company?
It was a racial joke that I reported to my foreman, Chris Blair. It was a racial joke, you know, saying, the guy said to me, what does a black man and an apple tree have in common? And I was like, what? No, I don't know. He said, well, they both hung from it, and he thought it was funny.
Got a minute left, Mr. Foreman.
Okay, all right, so you went on ahead and reported that?
Yes, sir.
Okay, so then you applied for this assistant project manager job.
Yes, I did.
And who did you apply through that job with?
I asked for the position through Brad Landis.
And what did he tell you?
He told me that he'll let me shadow one of the assistant project managers.
And what happened?
I never got to shadow the assistant project manager that I was supposed to.
So now you have been put in a hostile work environment. You haven't had any disciplinary issues on the job during your tenure there. You haven't received a review. The employer did tell you that you were doing a well enough job that you will be able to shadow this individual. So what are these credentials right here before us?
These credentials right here are certifications for a heavy equipment operator, which that's what I thought I was hired in to be, but I found out later I was hired in to be a laborer. I'm sorry about that.
So you are qualified, in fact, to do more than be a laborer.
Yes, sir.
So then, so shortly after the third incident, the third racial incident, then after that, you were uncomfortable. Now you done face racial tension on the job. So now you came where and filed a complaint.
I'm sorry.
Where did you file a complaint at that point in time?
I filed a complaint at the NAACP.
And then, Mr. Courtner, did you make contact with the Kelchner?
I did at the time, and I forgot who I talked to.
Tyler Kelchner.
Yeah, and I asked him about the incidents that Mr. Bright had brought up, and did he have any kind of forum to address the concerns that Mr. Bright had, and they did not. And I asked for any kind of documentation that they would have to address these concerns that Mr. Wright had, and again, I never got anything from that company.
Thank you. So he filed a complaint with the NAACP. Shortly after he filed a complaint with the NAACP, he was on the job for probably about a month after that, month or so, and then they terminated his employment. So once they terminated his employment, then he, of course, we directed them to the Ohio Civil Rights Commission, and, to the unemployment office to file for benefits. So the unemployment office said that, ruled in his favor. Said that they found no just cause why he was terminated, so he started receiving unemployment benefits. And in the unemployment, so basically what they were saying is that he was not doing his job, and that the job did not change since the date he was hired. But the employer, Kelchner, did not respond to the unemployment situation at all. So at that point in time, he did receive unemployment benefits, and shortly after that, he did file with the Ohio Civil Rights Commission. So when he filed with the Ohio Civil Rights Commission, who called you and made an offer to you?
Anthony Corona.
And what kind of offer did he make to you on behalf of Kelchner?
He offered a settlement.
And what type of settlement? How much was that?
$15,000.
Okay, and then he called you a second time. Is that not correct?
Yes.
And what was that settlement for?
$20,000.
Did you accept that offer?
No, I didn't.
And then what was the third? Yes.
Yeah, I believe what I'm hearing is some, because let me preference this. In our cases, anytime a case is filed with the commission, and it's one of the things we pride ourselves on the commission, is we immediately offer the process of mediation. And what that does is that eliminates, hopefully, the end in the process. And we, the commission, we don't participate and we don't get involved in it. So what I'm going to ask you to do is don't discuss the matters of what was discussed during mediation, because that makes it very complicated one for what we're trying to rule on.
Okay, yes, sir.
Okay, no problem.
Yes, sir, Mr. Chairman. So after that, he eventually received a letter from the Ohio Civil Rights Commission in saying no probable cause. So that's what basically brings you today, and then you all made a ruling that he would be allowed a hearing, and we appreciate that.
Thank you, Mr. Farmer. Counsel for the respondent, you may identify yourself for the record and introduce your parties, and you may proceed with your 5 minutes.
Thank you, Mr. Chairman, and commissioners and guests. My name is Ian Mitchell. I'm an attorney with Reminger in Cincinnati, Ohio, and I have the privilege of representing Kelchner Incorporated today, which is a construction company out of Springboro, Ohio. With me at the table today is Kelchner's Director of Human Resources, Karen Van Sant. She is not only the most qualified individual in the company to talk to its respective EEO policies and procedures, but she also was involved with the process of working with Mr. Wright as the charging party in this case throughout his employment. In fact, she started about the same time with the company as he did as well. There are a couple things that I want to mention just in an introduction, but obviously I want the commission to keep in mind that, or at least put into some context, that I think we're going to have some disagreement on what the facts are in this case. Honestly, some of the disagreement is between what we've heard today and what's actually in the charge of discrimination. As this commission is probably aware, and I know the Dayton office that worked on the initial investigation is aware, Kelchner provided numerous documents involving the personnel file and the investigation of any claims that charging party brought to his employer throughout his tenure with the company, which again was only about 10 months. But as part of some of the investigations, which as you'll find out from the matters that I'll discuss in a couple moments were not related to discriminatory conduct, but simply to workplace discrepancies or disagreements that he was having with other coworkers and management. Ms. Van Sant conducted several interviews in order to just try to investigate what the nature of those complaints were, and recorded those interviews, and we provided those to the OCRC. And I think any review of those recorded interviews would demonstrate that there's a substantial disconnect between the things that Charging Party was saying to Kelchner and the Human Resources Department at that time and between what he's now saying today. Really, the crux of this case, as was demonstrated by the regional staff's report, the crux of this case involves Charging Party's disappointment at the company's assessment of his performance doing a particular audition, if you will, or tryout for an assistant project manager position. It is absolutely accurate that Charging Party started with Kelchner in about August of 2014. There was an incident in September of 2014, shortly after he started, that he reported to the safety director, Luther Hall, who is an African-American safety director with a long-standing tenure with the construction company. That comment, pursuant to Kelchner's policies, was reported up through the EEO procedure, all the way up to Ms. Van Sant, who investigated the comment by the other coworker. When she was satisfied that he had in fact made the comment, she didn't hesitate. She terminated him right away and recontacted Charging Party about the result, and he indicated that he was satisfied with that result. At that time, he did not make any other complaints about discrimination or treatment in the workplace that was in all related to his race. In fact, what we just heard about Mr. Hightower was not something that has ever been reported to Ms. Van Sant, and I think Charging Party indicated that he did not report that complaint himself. Charging Party is, by all accounts, an extremely ambitious individual, and I don't think there's any contention to the contrary here. From the very moment that he started with Kelchner as a laborer, which is an entry-level construction position, as opposed to a heavy equipment operator, which is something that has to be earned through on-the-job skill and ability. He started as a laborer and had to work his way up to the top, but on a regular basis, Charging Party would go to his supervisors and ask for promotion opportunities because he felt that the laborer position was below his education and training. He was consistently counseled by some of his coworkers, including Mr. Luther Hall, who again was the safety director with the company, later a foreman and also an African American, that the education that he had received in his professional training school was not sufficient for the environment that they were in, that really what he needed to try to obtain were the skills and abilities on the job site in order to qualify him as a heavy equipment operator. Undeterred by this encouragement to continue to work hard and to follow instructions, again, being very ambitious, he sought out the assistant project manager position through Brett Landis, who's now a vice president with the company. He was provided that opportunity to audition with an existing assistant project manager, who's Tony Marks, who's the gentleman mentioned as the shadow in this case, who he was intended to shadow. He did, in fact, receive instructions to work with Mr. Marks. He was given specific instructions on a silt sock measuring task that he was supposed to do, and that when he was finished with that task, he was to report to Mr. Marks. I think it's a little disingenuous to say that he never had the opportunity to shadow with Mr. Marks, because the instruction was specifically to work with him to report those measurements and to determine that he had done them accurately. At the end of the day, Charging Party decided to go around Mr. Marks and submit those directly to Brett Landis, the vice president, and when he found out that they were done incorrectly, he was directed back to Mr. Marks to correct them. Unfortunately, he did not do that a second time on the second day of opportunity being able to do that, and again took them back to Mr. Landis, and they were again incorrect. As a result of that subsequent inability to follow directions, he was counseled that that was essentially an elementary task of the job, that he needed to be able to follow those instructions and report to his supervisors accurately and not disobey those directions. The initial complaint that was lodged with Ms. Van Sant was not a race discrimination complaint, and I apologize if I can have just a little bit more time. The initial complaint that was filed with Ms. Van Sant in relation to the assistant project manager position was that he was offended that Mr. Landis had said that this was an elementary task of the job. The recorded statements that we provided to the commission indicate that the issue that Mr. Wright was most concerned with was that he was essentially being called stupid by his supervisor, and that felt that that was sufficiently in front of his peers that it was embarrassing to him. In actuality, again, he was just merely stating that this was an elementary task of the job to follow directions and to report to his supervisor. Again, it had nothing to do with discriminatory animus. It had nothing to do with his race whatsoever. In fact, the gentleman that eventually took that job, the assistant project manager job, when the audition with a charging party failed, is an African-American male named Tamar Peterson. He tried out the audition, did well, and ultimately received the position. Kelchner has a comprehensive EEO policy that it follows its policies and procedures very well. I think the record demonstrates that in each case where a charging party brought anything to the attention of one of his supervisors or HR, the policies and procedures were handled properly. Ultimately, the basis for his termination was his embarrassment at not getting the assistant project manager job, and when he was put back on as a laborer in order to drive haul trucks, he simply did not want to do those tasks and continued to complain to his management that they were beneath him. And ultimately, his supervisor let him know that it was not working out, and that was going to have to be it. The comments about the NAACP being involved, that did not occur from Kelchner's standpoint, from the records that we are aware of. That contact did not happen until after he was already terminated in June 2015. So the suggestion in his request for reconsideration that it happened back in April when he was auditioning for the APM job is not consistent with our understanding of the facts of this case. What I would say to support that is that when he was, another recorded interview was taken in June of 2015 in regards to the reasons why he was being let go, he did not mention any discriminatory aspect of his denial for the APM job in either the April interviews or the June interview. And in the June interview, it's the first time that he mentions the NAACP. So I appreciate the Commission's time. On behalf of Kelchner, I would respectfully request that the Commission adopt the report and recommendation of the regional staff of the Ohio Civil Rights Commission. Thank you.
Okay, thank you, Councilor. Questions from commissioners? Okay, the commissioner who always likes to go first, Commissioner Mirage.
I just happen to be on the right. To Ms. Van Zant, thank you for coming and being here. My question is this. When you conducted an investigation into the use of the N-word by the individual that you eventually fired, and I commend you for that, what other information did you obtain about the environment?
The other people that I had interviewed on the site didn't know anything of the comment. It was a conversation that was just between the person that was let go and Stefan. So I couldn't find any other evidence that anything else had went on. And Stefan didn't bring anything else up, so I didn't go any further than interviewing the guys on the site.
Have you received any other complaints of kind of an environment that is free and, you know, making racial or any other kinds of offensive comments or jokes?
Not since I've been there. I've been with a company about 1.5 years.
And what is the racial makeup?
We do have minorities, but it's primarily Caucasian.
Primarily Caucasians.
We do have African Americans and a few female laborers as well.
If I could also add to that, I'm aware that Kelchner has a minority recruiting program that they actually utilize as well, despite the demographics of their employment base.
And how big is Kelchner?
Right now we have about 250 employees. Sometimes that gets up to be nearly 400, but it's seasonal and it depends on the contracts that we have.
And I was trying to track just in his employment, he was laid off twice?
And no, he was laid off one time, and that was after the West Virginia work stopped. The two he was off for a week at a time, 2 times after that. But the first time it was because he requested a transfer back to Dayton, and we were trying to see if we could accommodate that. At the time we could not because there were people laid off in Dayton, so I couldn't bring him back to Dayton. So then he went back to work at the Cadets site where he was at. The last time there was a discrepancy about what happened, the Mark Wellborn, the superintendent, had let me know that he had terminated him, and Stefan had said he was laid off and ready to go to work in Dayton. So then that week in between was also where I was investigating what happened. So both of those 2 weeks that came at different times were more me investigating, trying to find what happened, and until then we were going to wait and see where to put him.
And were they paid suspension or paid time off
It was unpaid.
It was unpaid. So he complains about a situation and then he gets, well, I guess it was because he'd been terminated and so you
The
turned it
second
to
time,
suspension?
yes. The second time, the first time I thought he was requesting a transfer. So he had went back home to Dayton and wanted to go home. So I thought he just wanted some time off and I needed to investigate if we could put him back in Dayton.
Sure, and if I could clarify,
Sure.
Commissioner, from the recorded statements that we provided, when Mark Wellborn granted charging party's request for transfer back to Dayton, initially the process was that had to be approved through the HR department through Ms. Van Zandt. So he did inform Mr. Wright that he would be willing to sign off on his transfer request. Mr. Wright actually left the work site shortly afterwards, so to travel back to his family in Dayton. So he actually was just away from the website, or from the work site. Conceivably, he could have continued to be at the Caddis rail yard and to continue to work while the transfer was being processed if he had wanted to. But he voluntarily left to go back and visit his family in Dayton.
In Dayton. I think that's all I have to know.
Mr. President, do the commissioner do any public sector work?
We do.
Okay. Do you have, then, I assume then you prepare a federal EEOC plan?
We do.
Okay.
And we just were awarded a renewance of our compliance certificate, so.
Right. Then I know you were talking a little bit to Commissioner Ross about the makeup of the employees. Then if you file a EEOC plan, then you should know what those particular numbers are. Could you share with the commission your numbers for last year, please?
I'm sorry, I'm gonna have to find that
That's
because
okay. Take
I
your
don't have it
time.
memorized.
Take your time. Just don't take all year. I understand.
This is a little outdated, so it's from last summer.
Last summer, okay, that's fine.
But we had a total of 262 employees. There were 4 black males, 1 American Indian male, 1 mixed race male, 13 white females.
13 white females?
White females.
And that was out of 262?
Yes.
Okay. Okay. Thank you. Additional questions from commissioners?
To charging party, who made the joke about the tree, the apple tree?
The guy that made the joke was, his name was Robert Hawthoffer, and I did let the respondent know. I let Chris Blair know. Chris Blair told Mark Wellborn. Mark Wellborn contacted Karen Van Zandt, and Karen Van Zandt, I spoke with her over the phone, and I also told her, I have it in my notes because I wrote everything down. I also told her that I didn't want any retaliation because I knew it was a target on my back. I knew it was.
And how soon after that were you terminated?
Probably maybe 3 weeks, a month after that.
Can I just make a point?
1 second. We'll get to you.
That's fine.
She's fine. Go ahead.
Yeah.
Okay. One thing I just wanted to comment on, is that typically if an employee is not performing up to expectation, there's some type of disciplinary action, there's some type of progressive, practice, whereas the employer will say, hey, maybe need to take these steps, to get you in the direction that you want to go. I don't believe that within 10 months, probably at that point in time, 8 months, that he would be given, if he was not performing well, that he would have been given an opportunity to shadow for an assistant project manager position if he was not performing well. Then secondly, he would not have been given the opportunity, or there would have been some type of disciplinary, some kind of documents inside of his record, inside of his employment file. So none of that exists, and it doesn't exist because he was performing well. What exists on the job there is an environment conducive to racial discrimination, and retaliation. And in addition to racial discrimination and racial intimidation. Here it is, you have a young African-American male on the job, has credentials that he shared with you, was given an opportunity to shadow someone. So apparently his performance was not lacking. Because his performance was lacking, he would not have been given opportunity to do that. So when we look at what has happened in this short period of time, there's 3 incidents of racial incidents that has taken place, 2 of which were reported, 1 of which he felt close enough to his roommate, or his roommate felt close enough to him to even share that took place. That these individuals on the job, when the African Americans are not around, that there's nothing but jokes going on in the office. And as you just heard about the demographic makeup of the organization, now it doesn't mean that everybody is that way, but here's a Caucasian male telling you that that's the environment inside of the company, inside of the organization. So when we look at the short time frame from when he started making complaints, then now all of a sudden he's terminated within 10 months. So he came to our office, he filed a complaint on April the 3rd. So when he filed the complaint on April the 3rd at our office, then he actually filed the complaint with Mr. Kortner. Mr. Kortner then, shortly thereafter, contacted their office. So their office knew that the NAACP, that Mr. Wright had contacted the NAACP. And shortly after that, he was dismissed with no bad performance appraisals inside of his work history, with no write-ups inside of his work history, inside of his file. So if they can explain to me his performance, how they are stating that his performance was so bad, why was he given an opportunity probably by 7, 8 months into the job?
And I'd be happy to address that.
Counsel.
Sorry, I'd be happy to address that. First, the statement that he never had any disciplinary actions or verbal warnings of any kind during the entire 10 months that he was at Kelchner is also, with all due respect, discordant with the facts. We provided documentation in the OCRC document production where he received a verbal warning in December of 2014 relative to disobeying instructions while driving a haul truck and driving them onto a job when it would put risk to other oncoming trucks from colliding. Those safety regulations rules are in place specifically so that trucks don't collide with each other on the workspace. And in spite of the fact that he was told by the foreman who was working on the job to stay put, he continued to drive forward, putting both himself, his vehicle, the vehicles of the other individuals, and the other individuals themselves at risk. So he was given a verbal warning for that. That was also documented and put in his file and provided to the commission. There was a subsequent verbal discipline that occurred in April of 2015 relative to failing to wear a seat belt as part of the normal safety regulations of the workplace. Coincidentally, 2 other individuals were disciplined for doing the exact same thing on the exact same date. Both of those 2 individuals were white. So to suggest that he never had any disciplinary issues while he was at Kelchner is somewhat disingenuous. He did get constant feedback. The fact that he was a 10-month employee explains why he didn't have an annual review. He had not completed 1 year's worth of employment at that time. He did get consistent feedback. Luther Hall, again, the African-American foreman with Kelchner with a long-standing tenure, provided testimony to the OCRC investigator that he gave charging party feedback on a regular basis about both his attitude and his job performance, and suggested to the investigator that if it were up to him, he would have let charging party go a long time before the company did. And that was based upon just his own personal assessment of charging party's ability to follow directions, to obtain the skills and abilities on the job, and again, have nothing to do with racial animus. The other aspects that I wanted to get to is number one, the joke by Robert Hofhopper, the so-called tree joke that was discussed earlier. When Karen Van Zant, Chris Blair, and Mark Wellborn were involved with that comment, that incident, what was reported to them at that time was a comment that Mr. Hofhopper had suggested to Mr. Wright that he looked like a character, he said he looked like a colored character that he had seen on a TV show. That was the complaint and comment that was related to Chris Blair. Again, pursuant to the EEO policy, Chris Blair ran it up to Mark Wellborn. Mark Wellborn ran it up to Karen Van Zant. Karen Van Zant contacted Charging Party to see what happened, to try to understand the context of what was said or if he was offended by it. And she was informed by Charging Party not to investigate it, that it wasn't offensive to him and it wasn't a big deal, and he didn't want anything to happen. So to suggest that the company retaliated against him for something that he didn't want pursued, I guess I don't understand how that falls under protected activity. I know protected activity law under Title VII is very broad, but if the employee is specifically saying, I'm not offended by this, don't do anything about it, and the company doesn't do anything, if he's subsequently terminated for legitimate business reason down the road, I guess I fail to understand how that can be retaliation. And the last item I wanted to address was the demographics. The numbers are what they are. Frankly, this is a construction company that operates in eastern Ohio. The ability of the company to find African American or minority employees that are willing to go to eastern Ohio and work on construction sites is very limited. As a company that seeks out high EEOC compliance ratings, it does have an active recruiting program for minorities in their company that engages on a regular basis. They go to job fairs specifically to market their company to prospective African American employees and other minority employees. They do what they can in order to boost those demographics, but part of it is just industry related. They just cannot get the numbers to work in that region of the state on that type of job, artificially. They do the best that they can, but they cannot force those numbers to be higher. And it certainly doesn't have anything to do with an indication as to whether the company is invaded with a racial animus whatsoever.
Mr. Patman.
Yes, to the respondent, I'm curious as to, and this is Ms. Van Zant, right? This comment about the apple and then this comment about you look like a colored character. Is it your experience that if the party that reports it feels as though it's not offensive, that's okay, or do you look at that and evaluate it based on your company's policies and objectives?
I basically look at the situation, and the situation, I never heard the joke. This is the first time I've ever heard of it. So the context that I had got, or the story that I got, was they were having a discussion about TV, and it came up that he looked like someone on TV. So I did, call Stephen to find out some more information, and after talking with him, I didn't feel like it was a big deal, so I didn't investigate it further. If I thought there was something there, I would have absolutely went out and done an investigation like I did in some of the other instances with Stephen. But in this case, I just didn't think there was anything there.
Now, I'm a bit confused because did Charging Party report this?
No, he did not, but I called him.
Okay. How did this incident about the apple in the tree and the colored character, how did that surface?
I reported it to Chris Blair. I reported it and told him that I was offended about the racial joke. Chris Blair contacted Mark Wellborn. Mark Wellborn contacted Karen Van Zant. They know about it. They just not saying it. That's what it is.
Did you ever have a conversation with her about this incident?
Yes, I did. I didn't tell her. Yeah, I did. I told her that. What did I say in my notes? I told her that I didn't want any retaliation from either side. That's why I felt like they didn't investigate it. That's the truth.
So your specific response was not that you were not offended, but that you did not want to be retaliated.
Because I knew I had a target on my back.
Mm-hmm. Now, after this statement was made, how long after that were you terminated?
3 weeks, maybe a month after that.
Okay, right. And I think from the record, you were terminated by your immediate supervisor?
Mark Wellborn, yes, sir.
Mark Wellborn. And this is the individual that you reported the comment to?
I reported it to Chris Blair. Chris Blair reported it to Mark Wellborn. Mark Wellborn contacted Karen Van Zandt.
What is Chris Blair's position?
He was the foreman.
Foreman. And Mr. Wellborn again?
It was a general superintendent.
And you know about this incident, but you said that based on, you've never heard these statements before.
That's correct.
Right.
That's
So
the situation that I was told was completely different than this, and Stefan never brought up retaliation.
Right. So no statement was made about apples and trees. No statements were made that you look like a colored character on TV.
No, that did come up.
That came up?
Yes, the colored part came up.
Yeah, I was wondering. I just, it seems to me that you need to look at your company policies and check. That's why I asked you, irrespective of his comments, however we accord whatever credibility we accord to his comments, do you personally, having, the job of maintaining the culture and character of the company, do you feel as though that's an appropriate comment in the workplace?
And again, you have to understand construction. All of the Caucasian guys have nicknames and they refer to each other like I know one in particular that's called Lenny because he looks like a Lenny character on TV. So I didn't really at the time associate that with, racial discrimination. I just thought maybe they were giving each other nicknames like they do.
Right, but the specific claim I heard here was that he looks like a colored character on TV. That's a little different than saying you look like Lenny. Did you find that use of that phraseology was offensive?
No, I thought it was a little outdated. I refer to people as African American or black, but then everybody's different. So.
Right. Can you understand if someone might find that offensive?
I can see both sides of it. That's why I called Stefan and asked him.
Right. And what did he say?
He said he wasn't offended by it and didn't want to pursue it and did not want me to investigate it.
Did you talk to the person that made the comment?
He's no longer with the company, but no. I did talk to Mark Wellborn, and I talked to a couple other people, and
Right.
It was hard for me to even find out who made the comment. I didn't find out who actually made the comment until actually we were going through this investigation. At the time, nobody would even tell me who said it, even Stefan.
Okay. Last comment. Has he been replaced? His position been replaced?
Stefan's?
The charging party?
Yes.
Could you just clarify whether you mean the assistant project manager or the laborer?
No, I'm
position?
talking about the charging party. Is Stefan Wright? He's been terminated, right?
That's correct. He was employed as a laborer, but he also auditioned for the APM. I just want to make sure she understands which position.
So maybe you can answer this, Counselor. Just looking at this prima facie test, was he replaced by someone? Was his position specifically replaced, or were his job responsibilities split up among other people?
The laborer position comes out of a pool of employee resources that the company has, and so they are always hiring African American and Caucasian and peoples of any kind of demographics into that pool. So to say that his specific position was replaced by a person of any particular race would be difficult, because the crews just work with whatever they've got.
Well, let's simplify it. Seems as though I have some experience with construction. If you got 10 laborers on a job and you get rid of one, and you got 10 people on that job, did you hire somebody so you had 10 people on that job?
I honestly don't remember. I mean, it's possible.
And again, it would just be simply because they came out of a pool. I know Tamar Peterson, the gentleman that we've talked about that eventually took the APM job, started just before the charging party was let go. They worked together for a short period of time. So it's entirely possible that they had one more laborer than they potentially needed, and then when charging party left, they were at the equilibrium point or whatever of what they wanted for that site. I think what Ms. Van Zandt is saying, it would be difficult to say, considering that those employees come out of a pool based upon their availability to travel to Eastern Ohio.
Oh, I understand that, but
Sure.
you have projects, and you have project requirements, and my family's been in construction, but my dad's a construction engineer. I've been around this my whole life. You have a project, you have project requirements, you got 10, 20 people. This is a simple question. When you fired him, did you just say, okay, we got to have another guy? I mean, these projects aren't done that way. They're done where you determine labor, equipment, that you need on a particular job, and then you have that there. Now, the numbers may fluctuate based on the job, but on a specific job may take 2 or 3 months. When you terminated him, did you replace him? That's the only question I had.
Sure.
Now, with respect to the promotion, I thought I heard that the promotion that he sought was eventually given to an African American. Is that correct? Okay. And now, when in record, I heard that I read, and maybe this is outdated information, that he was training, and it was possible he's going to get the position. Does he have the position now, or is he still preparing for it?
Mr. Peterson did ultimately take that job. He did audition for it and get it.
All right.
And it's worth noting that the existing APM individual that trained both Charging Party and Mr. Peterson for that position is also African American and continues to work for the company.
Thank you very much, Mr. Chairman.
Mr. Farmer.
Yes, Mr. Chairman. If I look at things just from a time perspective, he was hired in August. 2 months after he was hired, then he faced his first racial incident. 2 months after, he reports it. The person is terminated. A few more months after that, he faces his second racial incident. He did not report it because the individual came to him as a friend. Probably a month after that, according to the complainant, he received a verbal warning, something about the trucks. A few more months after that, there's a racial joke, and I don't consider any racial insensitive, I don't consider any of them jokes. I take them seriously, and the NAACP takes them seriously. So nothing is considered a joke when you're calling somebody colored, a nigger, the N-word, a mud shark. None of that is a joke. This is serious business. And for a company, HR director saying that she didn't feel that was insensitive, that's concerning to me. Very concerning. Then when you look at verbal, he was given a verbal warning in that same month for a seatbelt violation. I would like to know, and then a month later, a month to probably a day later, he was terminated. Is there a progressive disciplinary policy that they have in place? According to them, he has 2 verbals. He was never, we asked him at the beginning of this conversation, have you ever received a written warning? No. Have you ever received a review? No. And they answered that question that it had not been a year yet. But if he was not doing the job, or if his job, he was underperforming, there should have been some kind of progressive disciplinary or some kind of system in place to be able to say, hey, you're not doing a great job. You're not doing the job that we need for you to do. But instead, he gets kudos and say, shadow this person for an assistant project manager job. It's not making sense. It's not adding up. If it isn't right, you must indict. If it isn't right, you must indict.
If I could clarify real quickly, that the criteria that he was perfectly qualified for the APM job based upon his work prior to that point, it requires a little bit of a distinction. He had been hired as a laborer, which again is the entry-level position on the construction work site itself, does physical labor. The fact that he had not been working up to the standards that they had been asking for him, it is not necessarily relevant to whether or not he was going to get the APM position. The APM position is primarily an in-office support position for the project manager. So essentially what they do is a lot of administrative work, some clerical work. The specific task, as I mentioned, that Charging Party was asked to do as part of this audition was simply to measure the silt sock, which is, I didn't know what it was, but it's a membrane that goes around a construction site. And then those measurements are taken and transferred to an invoice, which is given to the client. It's important that those numbers are correct so that the client gets invoiced properly. But I think that just demonstrates that the APM job was an office position, that any performance that he had done in the field wouldn't necessarily equate to. In fact, I think that's the number one reason why charging party wanted to obtain this APM position, was because he wanted to get out of the laborer position, wanted to get off the job site. So that's why the opportunity was afforded to him, so that he could have that opportunity to get out of what he didn't want to be doing. And ultimately, that was one of the reasons why that he ultimately was terminated. I mean, his performance had been low, but after the APM position didn't go, the audition didn't go the way that he wanted, he became more and more frustrated. And again, the recorded statements from all of his coworkers demonstrate, he became more and more frustrated with the fact that he was just a haul truck driver, that he was being asked to remove mats from the railroad tracks. And when he would continually try to shirk those duties and get out of them, that's when the negative feedback from his coworkers and from his supervisors came, that he felt more and more frustrated with. So it was mostly the fact that he didn't want a job anymore and was continuing to complain about it. Those were the reasons, along with his poor job performance, as to why the termination decision occurred the way that it did. So again, just to clarify, the APM position is an office position that doesn't necessarily have anything to do with his work as a laborer. I think the record demonstrates, based upon the recorded statements, but also the write-up that was in his file, that he had safety issues. He had received counseling from Luther Hall that said that he did not have the abilities and skills to be the heavy equipment operator or whatever position that he wanted to, that he was ambitious towards. And again, it's Kelchner's position that charging party is a good individual. They're not saying he was a horrible employee. They're not saying he was a horrible person to work with. He was just very ambitious, and unfortunately that ambition didn't always translate over to the ability and skill to demonstrate that he was worthy of being promoted. There was absolutely no discriminatory animus, but that's really the crux of what this case boils down to, is that he was disappointed with not getting that job. Thank you.
Thank you, Councilor.
Mr. Chair.
Yes, Mr. Farr.
All right. Now, now, once again, I believe what has been demonstrated here is that there is an unjust system that has taken place inside of Kelchner. I believe what has been demonstrated here is that this young man was given an opportunity to shadow somebody, so apparently his performance was not bad. Because this was during the tail end of his job there, when he was given this opportunity. What's been demonstrated, and not just demonstrated, but what the fact is, he has credentials. What's been demonstrated is we have an HR director that does not look at the word colored as offensive. What's been demonstrated here is that we have two situations that were reported, and a third that was not reported. Racial incidents on the job within 10 months. What's been demonstrated is, enough said.
Okay, well, and I'm not going to, I understand, Mr. Farmer, and I think you know that this commission prides itself in trying to determine whether or not discrimination took place in the cases that are filed before it. We do know that the first time the charging party filed a case, first time the charged party felt though he was discriminated, he contacted the company. The company took care of the matter, and the charged party was satisfied. What we do know, secondly, that the charging party decided himself not to make the company aware of an incident. And what we do know on the third one, which is a little bit confusing in the sense that we've heard two different stories as to the alleged charge. And so what we have to do within the commission under 4512, we have to find the nexus of the discrimination that been alleged took place was the reason why the action was taken by the company. So if we can put those, and trust me, that's why we sit here, and it's an honor to do this, and we try to work at trying to figure that out. So if you can take those boxes and put them in those boxes for me and give me something, I'll take it and I'll shepherd and I'll run off with it. Yes, Councilor.
Mr. Chairman.
Yes.
Mr. Chairman, if I could illuminate some of that critical issue that you just mentioned as the context of the third incident that you're referring to. Because if it really is the crux of this case, I think it's fairly simply resolved. When charging party spoke with Ms. Wright over the phone on June 1st, 2015, which was the date when she officially informed him that he was going to be terminated with the company. She was going to stand by the original term. Excuse me, June 1st, excuse me. June 1st of 2015. That recorded statement, again, was provided to the commission, and in that conversation, she has a discussion with him that she's going to stand by the decision, and that is the first time where charging party suggests that this is about race. And that conversation takes place. He says, I can't help but feel that this has something to do with my race. And her comment to him at that time was, well, Stephan, if that's the case, why didn't you come and talk to me about this? Why didn't we have a discussion about this? And he says, oh, well, I thought we did talk about it, you know, from the comment about my coworker. And her comment to him was, but you told me that you weren't upset by that and you didn't want anything to happen as a result of that. And he said, yes, that's right. But I can't help but look back now that all of this had to do with retaliation of some sort. So hopefully that simplifies it. And again, and that's in the record that was provided to the regional staff, and I think that's ultimately one of the critical aspects to resolve that third issue that you mentioned.
Okay. Mr. Wright, you want to say something?
Yes, sir. Yes, sir. I worked out there in the field. They only know what they were told. I experienced it. I was there, and I reaped everything they said to me. They only know what they were told. I started writing down every time something happened to me or I had an incident. Like the incident we were discussing on May 12th, 2015, time approximately 12:40 p.m. That's when I told Mark Wellborn, and I spoke with him, telling him about the racial hostile environment that I was in. And it also says in my notes, if you want to read them right here, sir, that I didn't want any retaliation from any side because I knew it was a target on my back. I knew that.
And so you shared that with who all did you share that with?
I shared it with Chris Blair. Chris Blair told Mark Wellborn. Mark Wellborn told Karen Van Zandt.
Okay, Ms. Van Zandt called you?
Yes, sir.
Okay, and now walk us through the conversation with Ms. Van Zandt when she called you. How did that conversation go?
I told her just like I told
Now, Chris, now tell us.
Okay. I had a conversation with Karen Van Zandt telling her that I had a racial joke thrown at me. Yes, I didn't appreciate it at all. That I didn't want any retaliation from either side because I know I just came back because I was laid off for a week. They called it was an investigation. It was an investigation on me, but it wasn't an investigation. You know, I didn't get paid that whole week I was off work. It's been a couple of times I done been off work and did not get paid, but the other party got paid. They were still working, but I wasn't. I still got, you know, a family to feed. I still, you know, I wasn't working. I didn't get compensated for that at all.
So why were you off of work?
For their investigation, that's what they called it. They wanted to investigate what happened, but
Okay.
yeah, but I had no compensation for it at all.
Okay.
And Mr. Commissioner, sorry about that.
Hold on, Mr. Farmer. Yes, Councilor.
I was just going to clarify, the investigation that I think charging party is talking about would have been the May-April investigation, where after he did not get the APM position, he requested Mark Wellborn for the transfer. He'd been put back onto the work crew with Mr. Wellborn as general superintendent at the Cadiz Rail Yard job site, and he was working as a laborer. He indicated that he was frustrated with having to work at that laborer position and asked Mark Wellborn for a transfer back to Dayton. Mark said at that point that he was willing to sign off on that transfer request. And then again, after that, charging party could have stayed on the job site and worked while that transfer request was processed, but he elected to go back to Dayton to be with his family, hoping that ultimately he would end up going back there. As Ms. Van Zandt said, she was not able to secure a spot for him in Dayton because they were already laying off employees at that time. So she presented him with the opportunity to go back to the rail yard, which he agreed to, but then the period of time that passed was essentially a week. Now, it was not a layoff. She did investigate his suggestion that he had been mistreated. When she first talked to him about the transfer request, she said, why do you want to transfer? He said that he felt mistreated by Brett Landis. And again, that mistreatment claim, as it clearly indicates in the charge of discrimination, was solely based upon his comment that Mr. Wright had failed to fulfill the elementary task of the APM position, which again, he was insulted by, thinking that it was in reference to his intelligence, which it was not. It was just, you have to be able to follow instructions and be able to take these measurements if you're going to do an APM job. The second day, when he again failed to follow the instructions, to report those numbers to Anthony Marks, the person he was supposed to be shadowing, and then to relay those to Brett Landis, again, he had failed at that elementary task of the job, which was to follow the instructions. It had nothing to do with his race. It had everything to do with not being able to fulfill the instructions that he had been provided just simply the day before.
Okay. Additional questions from the commissioners? Any additional questions from the commissioners? Okay. Mr. Pat.
To the respondent, under your policy, I understand that he was only a 10-month employee, so you had no opportunity to do an annual evaluation, correct?
That's correct. I think there was that's in the file, there was like a new hire review or something, but it was so early in.
Right.
Yeah, I think he was doing okay at that time.
Is there a mid-year review?
No.
Okay. And we've heard that there were some verbal warnings here given. Under your disciplinary process, when it's performance related, does it progress from verbal to written, or is it enough to say, hey, it's verbal,
Frequently there's terminations without any steps at all. Obviously that's not ideal for me, but that's what's happening a lot, and that's happening with all other employees, not just African Americans.
Right. Is your employment manual, do the employees have access to employment manuals?
It pretty much says that we can do whatever we want, is what the policy says.
Okay.
Yeah.
So there's no mandated progressive disciplinary process? Okay.
Yeah.
All right, thank you.
Any additional questions from the commissioners? Okay, then commissioners, in the matter of Stephen Wright versus Kirchner Inc., what's the pleasure of the commission? Okay, that's a great question. Commissioner Aurora says she don't understand why he was fired. That's an excellent question. Counselor, are you eager to answer that question?
I'm happy to answer
Sure,
it.
go ahead.
Again, when charging party returned back to the Cadiz Rail Yard, he was disappointed with having to be a laborer, that he was not an assistant project manager. He was asked to do the work of a laborer, which involved a lot of physical labor. It involved driving a haul truck, it involved pulling mats off rail yards, it involved taking ditches, just about anything that you can imagine on a construction site that was physical. Again, that was not where he saw himself being, and that was what he had communicated to other individuals that were around him, coworkers. Again, Luther Hall, who was somewhat like his mentor on the work site, that's what he had mentioned to Luther Hall. And Luther continued to suggest that you need to be patient, to put in the time, understand how to master the skills that are required in order to move up in this company. Luther counseled him that he'd been there for a long time before he moved up to a foreman. It took 10, 11 years, just as it did anybody on the work site, to get that kind of experience and influence in order to get promoted on a construction site. However, in spite of that counsel, and in spite of those encouragements that you can succeed in this company, you can continue to move up, there just was not the patience to deal with that time component. And so charging party's complaints grew more and more substantial, that he didn't want to do the labor positions. And specifically, one of the tasks that he did not like to do and had been cautioned from his coworkers from avoiding was the issue with the mats. He didn't want to have to take those off the rails. So he'd find other things to do or conveniently disappear when it came time to do those tasks at the work site. So on the day in question, May 22nd of 2015, when he had a conversation with Mark Wellborn, again, after having returned from this, however you want to call it, parlay in Dayton, Ohio, he returned and was again being assigned a task for that day, which I believe was haul truck driving. I think that's the testimony that we had in the OCRC investigation with Mr. Corona. And again, at that point, he complained about having to do that and walked away grumbling under his breath, saying he didn't want to have to do that. And the general and superintendent, Mark Wellborn, that had assigned him that task, simply said, look, we can't continue to have these complaints. I think that's it. And at that point, they parted ways. And that was essentially the termination event.
So he was terminated for complaining?
Well, it was a combination of it. I'm sure Karen could probably speak more to it well, but it was the history of the performance issues, but then ultimately it was, again, because he was disappointed with not getting that APM job and having to go back to the laborer position, is what he could not get over. And again, she took extensive recorded interviews of his coworkers that all were universal in expressing the fact that he was vocal about being disappointed at putting back on the labor position and did not want to do that work.
And he complained about other things as well. So Wellborn, he was complaining to Wellborn about his job, about the environment, and Wellborn said, I think that's just it.
Well, to the extent that you said he's complaining about the environment, I'm not quite sure what you're referring to.
Well, he complained about a joke through his supervisor up through Wellborn that got to your office, I believe.
Well, the joke, again, is something we dispute factually, that the joke about the tree did not actually occur. Well, I don't know that it didn't occur, but I know that it was not reported. That what was reported was the comment about the television character.
Somehow Wellborn thought enough of it to report it to HR, right? A red flag was raised that said,
Correct.
I need to tell somebody that this came through my office.
Right.
It was offensive enough for him to repeat it to someone.
Correct. He adhered.
He doesn't waste people's time. And so he thought it was worthy of a phone call. I always worry when when companies don't take things into a different perspective.
I'd like to comment on the termination because I was the one that investigated that and ultimately made the decision to terminate him.
Okay.
What Ian said is absolutely correct. However, it was more than that. When I talked to, I think there were I can't remember exactly how many, but there were quite a few statements I took from the field. The one thing that came out for me was his lack of following directions also. Yes, he was complaining about not wanting to do labor, but it was also he was not following directions. He was putting headphones on and not on the CB. Things like that can get people injured and killed, and that was a concern for me, and that's ultimately why I decided to back up Mark Wellborn.
Yeah, what we're trying to figure out is what was in Mark Wellborn's mind when he decided. It sounds like...
Sure, but I could have overturned that if I felt like there was any issues with it.
Mm-hmm. I just don't know what what caused Mark Welburn to be particularly upset with
I
the
know,
complaints.
I know Mark personally, and he has deadlines that are very strict. And I know if people don't do what they're told to do when they're told to do it, they fall behind. And my guess is he was getting frustrated with the constant talking about what he was going to do and when he was going to do it, and he just wanted him to do it.
Got it. Thank you.
Mr. Martin, statutorily we're in June, is that correct?
That's correct. So June 17th statute,
Right.
Meaning that we do have at least a couple more meetings left. We have
Right.
April 28th,
Right.
May 19th,
Okay,
June 9th.
okay. Just looking at all the options. Okay. Mr. Farmer.
Thank you, Mr. Chairman. You know, don't you... Hello? Okay. I just want to point out two quick things. It's just very odd from a timing perspective that he was laid off after the termination. Yes, she did the right thing and terminated the guy for making a racial comment in the beginning in West Virginia.
Right.
She did right, and I applaud her for that. Okay? But from a timing standpoint, after that happened, he was laid off. So I applaud her for doing the right thing, but after that, he was laid off. Can you tell them, you know, the second time that you were laid off, when did that happen? And why did that happen? Because they're trying to say that you wanted to go home and you didn't ask for work. Can you talk about that?
March 28th, 2015. Like I said, I wrote everything down. It's right here in my notes. The reason I asked to go back home because I was being treated unfair, and it was unfair treatment. I wrote down, I was trying to keep busy and stay productive. I checked the oil in the 815 compactor. I started compacting the field, and I told Karen Van Zandt this also. I started compacting the field. I came over the CB and let my boss, Mark Welborn, know what I was doing to stay busy. He then told me to get off of the 815 because he didn't want me over there. Then turn right back around and put a Caucasian man on the same piece of equipment that he told me to get off of. I'm qualified to run any piece of equipment in the world.
Mr. Wright, when you say you were treated unfair, could be more specific? What are you saying? You were treated when you're saying you're not. How were you not treated fair? What about this unfairness? Is it relates to your race, or what? I mean, what is it? What is it specifically that you're saying?
I believe it was race. I would believe it was everything that I said, from a hostile environment to retaliation. About this incident, yes, I believe it was my race because you pulled me off of a machine that I know how to operate and operate well, and put a Caucasian man on it, and I'm doing the same thing that.
Now, who pushed you off the machine?
Mark Welborn.
Mr. Welborn.
Yes, sir.
And what Mr. Welborn's position was he a foreman?
No, sir. He was the general superintendent.
General superintendent. Okay.
Yes, sir.
Okay. Now now you know how to operate all of this equipment, but are there? Well, we do know that. Did you violate any safety rules?
No, sir. If you violate safety rules at Kelchner, they write you up for it. You know.
And so during your tenure of employment with Kelchner, you never were talked to about or spoken to about violation of any safety rules?
When they spoke safety?
No. Stick with me. My questions, and my questions are for a reason.
Okay.
So, during your tenure at Kelchner, were you ever spoken to about any safety violation rules?
In a group. In a group. Individually, no.
Okay.
In a group.
Okay, that's all right. Thank you. Director, did we? Yes, did we talk to Mr. Kilborn?
There is no record that the regional staff talked to Mr. Kilborn.
There's nothing in the record that you spoke to him during the investigation process?
I did not.
Okay.
During the reconsideration process, I did not talk
Hold
to
on
him.
a second. Stay with me, counsel. I'll get you. Okay.
During the reconsideration process,
Uh-huh.
I did not talk to him because the evidence that the investigation shows was, in my judgment, overwhelming in favor of respondent's decision. Did not find discrimination when all Caucasians were also discharged for the same reason. When the person also who used the N-word at workplace was immediately terminated upon internal investigation, I didn't find any need. Most importantly also, assistant project manager position that charging party aspired to, he was given the opportunity. When he failed, another black person was given that position. So I did not find a need for further investigation in my judgment.
Okay. Counselor, what did you want to say?
I just wanted to briefly clarify, just for the accuracy of the record, I think we were referring to Mark Wellborn, and he was
Wellborn?
Mark Wellborn, and Investigator Corona did speak with him as part of the process. With all due respect, I just wanted to make sure that was clear. He did speak with Mr. Wellborn. And one other aspect that I believe I failed to mention, on the exact same date the charging party was discharged from the work site, May 22nd, Paul Carpenter, another white laborer at the work site who is Caucasian, was also terminated for performance reasons as well. So there were actually 2 individuals terminated on that same date. Other than charging party, the other individual was white.
Was the individual that was terminated was Caucasian? Was he terminated as in the same situation where he had verbal warnings and then terminated, or was there more steps taken that led up to his termination?
There was no warnings with him. He was a newer tenured employee, I believe, in his first 90 days of employment. So he was doing quite a few unsafe acts and had been verbally warned. And when he did them again, they let him go.
Are there any, do you see any evidence of any people who had gone through that initial 90 days, who had cleared that hurdle, on their way almost to a year, who were Caucasian, who were given verbal warnings and then terminated for safety reasons?
Yes. Sometimes yes. There's not a lot of documents, and that's what I'm trying to work on with the Kelchner management team, is to start documenting things. So yes, since I've been there, I've seen a lot of people let go without any warnings at all.
If in fact we sent this back for further investigation, as the chairman is contemplating, is this information that our investigators could access and get so that we could do a further evaluation?
Yes.
Okay, thank you.
Since we're on the topic of additional information, do you have any other complaints that you've investigated, say, in the past 10 months regarding employees complaining of their environment?
No.
There are no others?
No.
Was he the very first one?
Since I've been employed, yes. I think Kelchner does have some that go back farther, but I was not part of that.
And there have been no others since?
No. Not that I can recall right now.
Are they kept centrally or in a place where you can look them up?
Yes. I mean, I would keep that as part of my investigation file, yeah.
Okay. Thanks.
Any additional questions? Okay. All right, we'll try again. Commissioners, in the matter of Stephen Wright versus Kessler Inc., what's the pleasure of the commission? Silence. Okay. Commissioner Barras got us raised the question, got us talking again. Is there another question? Yeah, I think Commissioner Patman trying to read my mind. Yeah, I was on the subject of trying to determine whether or not there is a need to remand the case back to the regional to get some additional information on those matters, but I'm not quite for sure whether or not I've got my questions answered to a large degree, and I would just ask of the commissioners, are there still remaining questions that you feel that will be germane to get an additional information that would be helpful to helping you understand this case better? Commissioner Shepard?
No, my questions have been answered.
Okay. Mr. Patman?
My questions have been answered, but of course, I need confirmation of certain facts, and I think Respondents Council made a good point that there is significant fact dispute here in this case. I don't know how to resolve it, however.
Okay. State. Commissioner Mirage?
I'm okay. I'm
You
comfortable.
okay? You comfortable? Commissioner Singh? You're fine. Now, your fact questions?
I've asked them.
You asked them?
Yeah, but my point is that when you have people disagreeing about certain facts,
right?
You know, as much inquiry as can be undertaken has been undertaken. So I guess the answer should be my questions are answered.
Okay. Okay. Then, Commissioners, in the matter of Stephen Wright versus Kettler Inc., what's the pleasure of the Commission? Commissioner Singh?
I move that we uphold the Commission's finding and deny the charging party's request.
Okay. There's a motion by Commissioner Singh that in the matter of Stephen Wright versus Kettler Inc., that the Commission would uphold the no probable cause finding and deny the charging party's request for reconsideration in the matter. Is there a second to that motion? Is there a second to that motion?
Second.
That motion has been seconded by Commissioner Cephas. And at this time, are there any questions or discussions on the motion? There's no questions or discussions on the motion. Ms. Ackman, will you call the roll, please?
Yes, sir. Commissioner Barreras?
Yes.
Commissioner Patman?
Yes.
Commissioner Singh?
Yes.
Commissioner Suspetta?
As well. At this time, I would ask for a motion to recess until we move up to, I believe it's room 103. Get a motion to recess until we convene for our presentation for lunch.
So moved.
Is there a second?
Second.
Second by Commissioner Barras. Any questions, discussions on the motion? Ms. Ackman, call the roll.
Commissioner Singh?
Yes.
Commissioner Barreras?
Yes.
Commissioner Patman?
Yes.
Commissioner Suspetta?
Yes.
Chairman Huber?
Yes. All right, thanks. We're going to go.